Limited Claimant and Super Industrial Services Limited First Defendant Rain Forest Resorts Limited Second Defendant. Appearances for the claimant, Ms. Deborah Peek SC, Mr. Jason K. Mutu, instructed by Ms. Alana Besesser. For the first defendant, Mr. Neil Bismuth, instructed by Ms. Lydia Mendonça. For the second defendant, Mr. Ramesh Lawrence Maharaj SC, Mr. Navindra Ramnanan, instructed by Ms. Odilian Pierre. Delivery date, February 8, 2019. Ruling 2. 1. By notice of application filed on March 27, 2017, the NOA, the claimant, NGC, sought the following orders. A. That the time for making the NOA be extended. B. That the NOA be fixed for hearing, if necessary, after the determination of NGC's appeal to the Judicial Committee of the Privy Council, JCPC or the Board, against the decision of the Court of Appeal, CA decision, dated November 23, 2016 in Civil Appeals Numbers P186 and P190 of 2016, whereby the Court of Appeal, CA, ordered. I. That the instant claim filed on December 24, 2015, the claim, was struck out pursuant to the provisions of Rule 27.3(4) of the Civil Proceedings Rules 1998, as amended, the CPR, and the action referred back to this court for a hearing as to an inquiry as to damages pursuant to the undertakings given by NGC on the injunctions granted by this court and for the assessment of costs, and 2. That NGC pay SIS's and RFRL's costs of the appeals, being 2/3 of the costs to be assessed in default of agreement, and C. At the hearing of the NOA NGC be granted relief from the sanction of the striking out of the claim by operation of Rule 27.3 of the CPR. 2. On July 16, 2018, NGC's appeal against the decision of the Court of Appeal was dismissed by the JCPC with the result that the instant claim stood automatically struck out pursuant to the provisions of Rule 27.3(4) of the CPR. Pursuant to NGC's request, the NOA came on for hearing later that same day, and directions were given by the court for the filing of affidavits and submissions relative to that application. At that hearing, the court 3. After entertaining submissions from counsel for the respective parties, also granted a freezing injunction against SIS and an injunction against RFRL, pending the hearing and determination of the NOA. The terms of those injunctions are in all material respects identical to those previously granted against SIS and RFRL, which remained in place pending NGC's said appeal to the JCPC. 3. With respect to the evidence before the court on the NOA, NGC filed 3 affidavits, namely, the affidavits of Alana Besesser filed on March 27, 2017, the first Besesser affidavit, July 16, 2018, the second Besesser affidavit, and August 30, 2018, the third Besesser affidavit. On 6 August 2018, Rainforest Resorts Limited, RFRL, filed an affidavit of Winston Siriram in opposition to the NOA, the Siriram affidavit. Super Industrial Services Limited, SIS, followed suit on August 9, 2018, filing an affidavit of Ramala Marriage in opposition, the marriage affidavit. Background history of the claim. 4. On the December 23, 2015, NGC made an ex parte application for and obtained a freezing order before the Honorable Mr. Justice C. Prasad, up to a limit of $180 million against SIS. The freezing order was obtained in support of an intended claim by NGC in arbitration against SIS for losses arising from the termination of a contract between NGC and SIS for the construction by SIS of a water recycling plant, the contract, and an injunction against RFRL. The injunction against RFRL restrained it from dealing with property and assets of CIS, the subject of securities granted to RFRL by CIS. B. The securities consisted of 4 mortgages over 4 properties owned by CIS and a debenture over all the assets of CIS. The mortgage deeds were dated the March 5, 2015, but registered in November 2015 to secure sums totaling $230 million. The debenture was dated November 12, 2015 and registered on November 18, 2015, to secure a sum of $100 million.
Issued a claim for seeking declarations and orders setting aside said mortgages. On the 4th of April 2016, the claim was automatically struck out pursuant to Rule 27.3. On the 31st May 2016, RFRL executed releases of securities and on the following day registered the releases. Thereafter, to add said releases. After hearing data on June 10, 2016, the court ruled that the claim was not automatically struck out due to a freezing order for excises assets to a sum of $180 million until the termination of the intended arbitration proceeding and restrain the property from dealing with and disposing of the securities. The court also ordered that said releases be expunged from the records of the Registrar General. A notice of appeal dated 14 June 2016, the defendants appealed against the judge's decision. The claim has not been struck out pursuant to Rule 27.3. Thereafter, the strikeout appeal. On the 23rd of November 2016, the Court of Appeal allowed the strikeout appeal and ordered that the claim was struck out. The claimant appealed the decision of the Court of Appeal dated the 23rd of November 2016 following the strikeout appeal to the Council. On the 16th of July 2018, the JCPC delivered judgment dismissing the appellant's NGC's appeal. As a result, the order of the Court of Appeal on the 23rd of November 2016 that the claim was in fact struck out. Part 27.3 was upheld. The first issue that falls to be determined on the application is whether the circumstances of this NGC order granted an extension of time for the making of its application for relief from the sanctions have been automatic. Civil Proceedings Rules 27.3 4.5 and case management contract requires this. The court does not dispense with the case management contract under 27.2 and gives directions under Rule 27.42 or 1 or B. Give notice of a case management in 14 days of the filing of the defense where there is only one defendant, 14 days of the filing of the last defense where there are 2 or more defendants, or 3, 14 days of the expiration of the period for the filing of the where there are 2 or more defendants. The claimant shall within 28 days of
D. On the April 4th, 2016, the claim was automatically struck out pursuant to Rule 27.341.
Pursuant to this rule, claimant lead the suit from court. You see how this, however, without prejudice to court, yes, it is to be noted that the sole consideration for the court in deciding an offense of paragraph 4 for the defendant provides the sanctions in CPR 3.7.
On the May 31st, 2016, RFR 1 National Gas Company of Trinidad and Tobago v. SAS and Aner. 5. H. On the November 23rd, 2016, the Court of Appeal allowed the strikeout appeal and ordered that the claim was struck out. I. The claimant appealed the decision of the Court of Appeal dated the November 23rd, 2016, allowing the strikeout appeal to the Privy Council, JCPC. J. On the July 16, 2018, the JCPC delivered judgment dismissing the appellant's, NGC's, appeal. As a result, the order of the Court of Appeal on the November 23, 2016 that the claim was in fact struck out pursuant to Part 27.3.4 was upheld. Extension of time. 5. The first issue that falls to be determined on the application is whether, in the circumstances of this case, NGC ought to be granted an extension of time for the making of its application for relief from the sanction of its claim having been automatically struck out. 6. Civil Proceeding Rules 27.3.3.4.5.6, under the rubric Case Management Conference, provides as follows. 3. If the court does not a. dispense with a case management conference under Rule 27.4.1 and give directions under Rule 27.4.2, or b. give notice of a case management conference within 14 days of the filing of a defense, where there is only one defendant, 2. 14 days of the filing of the last defense, where there are 2 or more defendants, or 3. 14 days of the expiration of the period for the filing of the last defense, where there are 2 or more defendants, the claimant shall within 28 days of the relevant period identified in 7. Pursuant to this rule, the claim herein was automatically dismissed on 4th April 2016 and NGC had until May 23, 2016 to seek relief from the sanction imposed by the rule. This, however, is without prejudice to the power of the judge, in an appropriate case, to extend the time for making such an application pursuant to Part 26.1d.
It is to be noted that the sole consideration for the court in deciding an application pursuant to subparagraph was whether the defendant is separated.
Extension of time, claimant's submissions. 9. The claimant submitted that in determining the issue of whether it should be granted an extension of time to file this application for relief from sanction, the court should have regard to the overriding objective and the issue of prejudice to the defendant. Applying the case of Rowley v. 7. Ramlogan 2. The claimant further argued that the weight to be given these factors was a matter for the court, having regard to the circumstances of the case. The claimant argued further that the court should exercise its discretion having regard to the overriding objective of the CPR outlined in Rule 1.1.1.3 to deal with cases justly. The factors to be taken into account in dealing with cases justly are enumerated in CPR 1.1.2 and are as follows. 2. Dealing justly with the case includes a. Ensuring, so far as is practicable, that the parties are on an equal footing, b. Saving expense, c. dealing with cases in ways which are proportionate to I. The amount of money involved, 2. The importance of the case, 3. The complexity of the issues, and 4. The financial position of each party, d. Ensuring that it is dealt with expeditiously, and e. Allotting to it an appropriate share of the court's resources, while taking into account the need to allot resources to other cases. 10. The claimant, relying on the case of Roland James v. the Attorney General of Trinidad and Tobago 4, contended that the factors set out in CPR 26.7, 1, 3, and 4 would generally be of relevance to the application and should be considered in deciding the application for an extension of time. 5. 2. Civ App 215 of 2014-3. The overriding objective of these rules is to enable the court to deal with cases justly. For Civ App number 44 of 2014, 5 claimants' submissions filed on September 28, 2018, para. 12. 8. The factors under CPR 26.7, 1, 3, and 4, promptness. 11. The claimant argued that it acted promptly in filing this application since A. From February 26, 2016 to May 25, 2016, after the statement of case and defenses of the parties had been filed, SAS and NGC engaged in without prejudice discussions which were initiated by the first defendant with a view to resolving the claim and, to that end, with the concurrence of RFRL, made repeated requests to the court to adjourn the matter to facilitate such discussions, with the last such adjournment being granted to June 21, 2016. B. It was not until the letter dated June 6, 2016 from SIS's attorneys at law that any suggestion that the claim might have been struck out arose, and that prior thereto NGC and its attorneys at law were of the genuine belief that it was wholly unnecessary for the court to have given further notice of a case management conference and or for NGC to apply for a date to be fixed for a case management conference, having regard to the fact that at all material times there was already in place a date of hearing for the matter fixed by the court. See, further, immediately following the assertion made by SIS's attorneys on June 6, 2016 that the claim had been automatically struck out, NGC filed a relief from sanctions application on June 7, 2016, the first relief from sanctions application. D. The first relief from sanctions application was eventually withdrawn by NGC on June 10, 2016 immediately following the 9. ruling of Charles J. on that day that the claim was not automatically struck out, which rendered the application ociose. E. Thereafter, until November 23, 2016, the day on which the Court of Appeal decision was delivered, Charles J.'s ruling that the claim had not been struck out remained operative. F. On the said November 23, 2016, the Court of Appeal, Noreen J.A., Jones J.A., and Rajkumar J.A., granted an immediate interim stay of the operation of its Order 6. G. That initial stay of the Court of Appeal was continued without interruption from time to time by various panels of the Court of the Appeal, Jamadar J.A., Musai J.A., Pemberton J.A., with the panel which heard NGC's application for final leave to the JCPC, Archie C.J., Musai J.A., Devine J.A., continuing the stay until the hearing and determination of NGC's appeal to the Board 7, and H. Notwithstanding the existence of the stay, out of an abundance of caution and entirely without prejudice to its position on the appeal to the JCPC, NGC filed the NOA on March 27, 2017, seeking inter alia an order that it be fixed for hearing, if necessary, after the determination of the appeal to the Board. 12. The claimant argued further that it could not reasonably be said that it was guilty of culpable delay in that A. NGC was conscientiously engaging in without prejudice discussions up until May 25, 2016 initiated by SAS, to the knowledge and concurrence of RFRL, 8 in an attempt to arrive at a global 6 Exhibit A.B.13 to the first Assessor Affidavit 7 Exhibit A.B.20 to the third Assessor Affidavit page 17 8 First Assessor Affidavit at paragraph 16 to 22. 10. Settlement of the claim. Claim. At the same time, the parties made successive joint requests of Charles J. to adjourn the delivery of her decision on the various applications for interim injunctions then before her, for the purpose of continuing those discussions, with the last such request being made on 17 May 2006.